Thank you very much. Hello there, everyone. It's 6 o'clock. Would you kindly take your split seats? Mr. Franks, can I welcome you to your first meeting of the Planning Authority? Yeah, but try and keep into your seat for the 6 o'clock start. You're just causing delay. Anyhow. May I remind everyone present that this meeting will be broadcast live via the internet and the record archive for future viewing, for those of you who want to go on it at a later date. Okay then. So, here we are. Apologies for absence. I know there are a number of apologies. Councillor Mark Wilson.
Yeah, I make apologies to Councillor Janice Birch and Councillor Rhiannon Birch.
Thank you. And Councillor Eric Hacker. Councillor Williams. Yes, and I know Councillor Pam Drake has apologised as well.
Jeff wants to come in.
Yes, and Jeff. Councillor Audrey Preston. With all those apologies, everybody happy? Yeah. Okay. Is it okay if I sign the minutes of the last meeting?
Yeah.
Thank you very much. That's moved and seconded by Councillor James and Councillor Jonathan Bird. So I'll sign those off. Now, we've got the exciting bit. Those of us who want to declare anything that is in this agenda. So it's declarations of interest. Nothing? How surprising. Oh. Yeah.
But I will treat the matter fresh on the evidence that's presented to me today.
Could you just repeat it, because I don't think the camera would have picked you up.
Okay, sorry. I need to declare that in respect of 1 Hastings Avenue, Penarth, I'm a member of Penarth Town Council and I've expressed an opinion at the Town Council in respect to this application, but I will treat the subject afresh according to the evidence given today.
Okay then, thank you for that. And I know Councillor Mark Wilson wants...
Okay, I would also like to declare the interest on the same point. I did express a view. I looked at the matter afresh in relation to 2014/01354/FUL/.
Okay. Right. Excellent. And Audrey Preston, you can go home because we've got apologies for you. No problem at all. Okay then, over to agenda item 4. Marcus, would you like to give us this site inspections report?
Nothing to add to the report, Chair.
There we are, nothing to add. Is it noted?
Yeah.
Thank you very much. Okay, so we've got agenda item 5 on page 1, building regulation applications, other building control matters determined by the director under his delegated powers. Marcus?
Nothing to add, Chair.
Nothing to add. Anybody want to add anything? No? Noted? Thank you. 6. Planning applications determined by the director under his delegated powers on page 8. Marcus?
Nothing to add, Chair.
There you are. Nothing to add. Any member? No? Noted? Okay, thank you for that. On agenda item 7 is appeals on page 16. I bet you've got something to say on that, Marcus.
Which one I haven't really. Only just say how we are pleased at the success rate in terms of defending appeals. We run 77%, which is the end of year figure. So that means that obviously we're well above the Welsh average for defending appeals against the council's decisions.
Thank you. Any member? No? All happy? Move we note? Yeah. Yes. Thank you for that. On agenda item 8, we've got trees. Anything to add, Marcus?
Nothing to add, Chair, no.
And the little I on delegated list. Anything to add?
No, Chair.
No. Move we note?
Yeah.
Thank you very much. over on page 22, which is enforcement action, little I, this is the land and buildings. Arisofa, is that right, Marcus? Arosfa, there we are. In UNE Road, Wick, on page 22. Marcus, would you like to lead us through it?
Thank you, Chair. Yes, this relates to a granny annex that was constructed or was approved in 2007, adjacent to a property known as Arosva, Wenny Road, Wick. It has come to light that the granny annex is now being used as a separate unit of residential accommodation and is not being occupied by anyone who has a relationship or connection with the main dwelling. So we're just seeking enforcement action to ensure that that breach is removed.
Thank you for that. So what we're noting, what we're going to move is that the head of legal services be authorised to serve enforcement notice under section 172 of the Town and Country Planning Act 1990 as amended to require the cessation on the use of the annex as a separate dwelling, the cessation of the use of the annex building in breach of condition 2 of planning permission, and 3, the construction of the internal doorway link shown on the plans approved by virtue of application reference 2007-01327 full. That was a mouthful. Members happy with what I've read out, that we move that enforcement action? All in favour? Thank you. Any against? That's clearly carried. Thank you. Marcus, on page 28, agenda item 9, you have another one. Land and buildings at Treguff Farm, holiday cottage in Treguff. Would you like to say anything about that?
Yes, Councillor Chairman, this is an interesting application or enforcement action. It follows quite a long-standing use at the premises for holiday let accommodation. The holiday let accommodation was approved in 3 separate batches, but ultimately there are 6 approved holiday let units at the property. Basically, there is a condition requiring that it be retained for use as holiday let accommodation. They are relatively small units and obviously would not really be suitable for independent units of accommodation. However, it has come to light they are being used by people to live in who aren't on holiday. They're living in them as basically either coming down and living in 5 days a week, working in the area and obviously going home at the weekend, or they're actually being lived in as residential dwellings for up to 9 months by separate individuals. They are actually being used as holiday accommodation as well, in between these various breaches. So what we're seeking to do in respect to the holiday accommodation is to serve an enforcement notice which would require the use to be maintained as holiday accommodation. I have to say something like this is very, very difficult to monitor, and by seeking the enforcement action, what essentially we're doing is protecting the council's position so that somebody can't claim a lawful development certificate in years to come for a use as an independent dwelling. Whether we'll be able to continue monitoring it constantly is a question that's very open. Obviously it takes a lot of time and resources to do that, but by serving this notice it does protect the council's position and ensures they should be retained as holiday accommodation. There is a separate issue in that one barn adjacent to these buildings has also been converted without any consent at all to residential accommodation, or should I say a mixed use of agricultural use at ground floor and appears to be residential accommodation in the attic or loft of the barn. We have tried to get or encourage the owner to actually apply for this, because there is given what's been approved on the yard and in other places, it's quite likely that it would actually get planning permission in terms of policy, certainly for a holiday accommodation, which appears to be what the owner wants. But they have said they don't want to comply with building regulations, so they're not going to apply. So we have to serve the enforcement notice yet again to comply with, to protect the council's position basically, so we don't get a sort of lawful use develop over time. So essentially quite interesting, but both of these actions are seeking to make sure that, well, in one way we'd like to try and bring the owner back to the table, so that they can talk to us again about it, especially with the one unauthorised use, where we do feel that there's no reason why we wouldn't grant permission if obviously all the correct issues were dealt with. So that's why we're seeking action here, to try and protect the council's position and obviously in a way bring the owner back to the table for discussions.
Yes, well, he should apply for planning permission like everybody else, but I know John Drysdale's itching to get in.
And Kevin.
and followed by Kevin Marnie.
Thank you, Chair. I mean, having heard what Marcus has just said about the first part of this and the holiday let with planning permission, it kind of makes my question slightly redundant, but I'm interested to know, because it seemed we would face a problem of definition here of how long is temporary and how do you define a holiday as opposed to somebody coming to stay for reason to visit relatives or to work or whatever. So perhaps it's a question for the lawyer that, you know, it sounds like we're not actually going to go to enforcement action on that line, but if we did, it sounds like we'd have a devil of a job actually dealing with it and making it stick.
Marcus. Thank you, Chair. Yes, you are quite correct. It is not an easy case to enforce. It's relatively easy in one respect, in that we do ask the condition, and the consent requires the owner to keep a register of people who are residing in the properties, and we would expect them to have a permanent address as well as the address they're living in now. So that in some way protects the council's position. In days gone by, we used to apply conditions saying you can't spend more than 2, 3, 4 weeks in one single stint, but Welsh Office inspectors have decided that shouldn't be used, because who are we to say how long somebody wishes to be on holiday? So it is quite a difficult issue to enforce. In this particular case, we served what was known as a planning contravention notice on the occupiers, and it was clear to us that although some of the units were being used for holiday purposes, at least 2 weren't. I think the Cardiff City goalkeeper had lived in one for 9 months and didn't have any other actual address to call as his permanent address. So we were able to establish fairly clearly that that wasn't a holiday let accommodation. But you are quite correct, it's not the easiest thing in the world to enforce, and in reality what we're doing is protecting the council's position, as I said before, to make sure that we don't lose these in the future as holiday let accommodation.
I'll see if the legal officer has got anything else to add.
I would just confirm what Marcus said. These are difficult cases in terms of proving such breaches, but you can have reference to websites in terms of lettings for holiday. So it's an evidential burden on us to prove in terms of any breach.
Okay, Councillor Marnie.
Yeah, thank you. My query is on a very similar line to this. How do you define this? I take on board what you've just said. I mean, I have a lot of relatives in Swansea, for example. Many people in Swansea have, for example, caravan homes down the Gow, whatever, that they literally use every weekend, even in good weather, finishing work, going out there as, if you like, their little oasis from the city, this sort of thing. On a lot of these things, you're paying council tax, a full year's council tax on them for a start. So the Vale is actually collecting that. I know there's restrictions on many of these holiday parks, if you like, that you can only stay for, you have to be vacant, or they have to be shut down for, say, 2 months of the year. I take on board what the lawyer said there, but even if you have somebody who, if you like, have bought a little place to get away from their home, if they're providing a second address, a primary address, if you like, I repeat again that they're paying council tax on a full year's council tax on their little property. If they want to use their second property, if you like, as much as they like to relax, how can you possibly say, no, you can't? So I would also point out, and I stand to be corrected here, that for registration for your vote, actually, I understand the definition is where you spend most of your time. So if you had somebody, let's just say, living in Cardiff, who had a holiday chalet or caravan home, complied with the 2 months or 1 month or whatever it is that they can't stay there a year, that these sites are normally shut down, how could you possibly say, well, you're not staying any longer?
Well, I think, as I've sort of said, you hit the nail on the head there by saying if you've got a permanent residential address, you comply with the condition. That essentially, that is how we deal with it. There used to be, you also referred to the case of people having to clear out a caravan site, and there are still some conditions on sites like that. But if they actually came back to us and said we want to remove that condition, we'd end up having to say okay and put a new condition on which said keep a register of everyone is there, prove that you've got a primary residential address and this is only holiday accommodation. And you know, to conclude, you're quite correct. We would then have very little control over how long they could be there. They could come there every weekend. They could come there, you know, in the week. So we wouldn't actually be able to stop that as long as they could prove they had a primary residential address.
That is the key, isn't it? The primary thing. I mean, I
You'll have to turn your mic off.
If they want to go to their little holiday place every day of the week, that's up to them, isn't it? But so I take on board your clarification of that primary address. Thank you.
Okay, Councillor Hodges.
Thank you, Chairman. My main concern here is that, as a council, we've spent quite a bit of money, and grant money at that, in pushing rural regeneration and tourism. Now, if these are advertised as holiday cottages, I'd like them to be available as holiday cottages so that people can visit from outside the area and spend their time and money in the Vale of Glamorgan. And if they're not being used properly, I'll say that, then that's an issue for the rural economy in that way. I understand people need places to stay long term or longer term if they're working here on contracts, but these are known as holiday cottages. It's the title, Trigger Farm Holiday Cottages, and I have an issue with this, and I understand the way that our planning officers are approaching this, and I have to support that, but it's not the way I want our rural economy, especially in regards to tourism, to be run.
Thank you. Councillor Jeff James.
Thank you, Chairman. I think that it's a shame, really, that it's got to this, because I know that the complex of barns were converted very sympathetically and nicely, and it's a really nice holiday-let area. So I hope that the action that the committee take tonight will bring about an amicable resolution of this, and that it won't get to the point of enforcement. But nevertheless, I think the planning committee and the council have to protect its own interest, which was that it probably wouldn't have granted permission for residential units in that area unless they were for holiday use, and we have to enforce the conditions of the original planning permission. So I'm pretty sure that, and I hope anyway, that it'll be resolved to everybody's benefit, particularly holiday makers in the Vale of Glamorgan. Thank you, Chairman.
Thank you for that, Jeff. Well, we've got 3 recommendations from the Head of Legal Services. One is the compliance with the requirements of Condition 8 of planning permission, Condition 3 of planning permission, and Condition 3 of planning permission under 97000823. And it's to require that the cottages are used for holiday accommodation only, the cessation of the use of the north barn for residential purposes, the removal from the north barn of all the kitchen and bathroom facilities, the boiler, radiators, internal walls, and any other items that facilitate the use of the building for residential purposes. And the key one is number 2, in the event of the non-compliance with the notice, authorisation is also sought to take such legal proceedings as may be required. That's the officer's recommendation. Those in favour, please show. Well, that's clearly carried. Thank you very much. Okay then, so we're on to the planning applications in full. We've got the first one, Pentline Estate Farm in Landhellig in Cowbridge, and I think there is an application from Andrew Parker.
Yes, thank you, Chair. This reflects the local concern. There are 3 main reasons that I'd like to ask for a site visit. One, so we can consider the effect on the special landscape area of the Upper Thor Valley. 2, a lot of discussion has taken place on the access to the site with the volume, but with the volume of waste now outlined here, there could be between 3,000 and 5,000 round journeys a year with lorries, and I think we need to understand completely how that's going to be handled. And finally, I would like to know what mitigation methods have been proposed for how the big proposal, when implemented, will have an impact on the effect on the local residents. So I would request a site visit.
Okay, site visit requested. Members happy to carry out that site visit?
Yeah.
Okay, site visit granted then. We're on to page 69. This is a reserve matters application for the layout and scale of 224 dwellings at land to the north of the railway line, which has been visited on many occasions. Over to you, Marcus.
Thank you, Chair. Yes, this is a reserved matters application following the outline application, which was approved some time ago. I think it was approved 2013, or was it? No.
Was about that.
2013, possibly early 2014. Just looking on the thing, 2014, January 2014. There we are. So this is part of that site that was approved in outline. This is for 224 dwellings for Persimmon Homes. Very quickly running through the scheme. You have it on the screen behind you there, or if you can make it out, it's a little bit blurry. But there is one difference to the originally approved brief for the land north of the railway site. The main difference being that instead of having two spine roads or two link roads going through the site, there is only one proposed at the top end of the site. The main reason for that is the school that is proposed on the other site, which would otherwise reduce the size of that site so markedly. There is a second reason, which is our highways officers don't actually feel that a second road is necessary, and that you'll see there's a loop proposed at the top there. That loop is to allow buses to turn if they need to turn, or to continue through the site to the Taylor Wimpey site, which went to committee last month? No, last month.
Last month.
So I'm not going to get into the discussion about whether that will happen or not, because obviously that's down to land ownership issues. But this is actually quite a good scheme. It does still have a number of cul-de-sacs, you will see there, and Manual for Streets, which is the document we work for, does seek to minimise cul-de-sacs. Obviously, you can only do that if your site allows it, and there are always going to be certain occasions where you will have cul-de-sacs. In this particular case, they have been minimised. There is a loop, you can see on the top corner, which goes right round the site, and part of that loop, which is marked in brown, will actually be shared surface. So it is taking on board all the newest sort of design cues from Welsh Government and from national government. There is affordable housing. You can see the affordable housing is shown in the pink colours throughout the site. So it is a good spread of affordable housing throughout the site, and it's pretty pepper potted. They're actually in quite nice locations as well, I have to say. Your officers are recommending this. It's taken quite a long time to get to this stage. We've had a lot of discussions and a lot of debate about housing numbers, about where the affordable housing will be sited, house types, and also about how they service the site, because one of the key issues is there are a number of bus laybys proposed. You can't actually see very well from where you are, but there is a bus lay-by proposed just next to the playing fields there. And that bus lay-by will serve both if there are any internal bus routes, but also serve to pick up children for school. So whatever happens with the link road or not, there is a method here that buses will be able to come into the site and exit the site without having to reverse or do anything else and pick children up to take to the school. So it is a scheme we feel has dealt very well with all the issues that were thrown at it. You'll see there's a large provision of open space in the bottom corner. What other key feature is the link through to Torbay Terrace, eventually through to the other site. You'll see that a footway cycleway is proposed all the way along the bottom of the site. That runs around the bottom of the playing fields as well. And obviously at the top end, where we go on to the link road going down to the rest of Roos Point, there is a zigzag path there which allows people on bikes to actually go up and down the path, and obviously there's people with disabilities to go up and down the path and use it to access the ultimately the station through the link through to Torbay Terrace. So yes, it is a scheme we're recommending. One key issue just for members to note, obviously drainage is an important issue on this site as a whole. This is a reserve matter scheme for the design of the scheme, for the layout of the scheme. There is a drainage scheme included within this design and layout, but it's not for approval as part of these details. That still is reserved by the original outline, and we'll be getting further details submitted as part of that original outline. We may in fact actually have an application to vary one of the conditions, because when that outline was approved, a particular drainage strategy was proposed in respect of sewage in particular, and it has been indicated by Welsh Water that they would rather an alternative strategy now to deal with sewage, which may mean they have to amend their condition, but that is again for us to consider at a later stage. So this is really the layout, design and appearance of the scheme. We're not actually approving the drainage matters as part of this approval.
Thank you. Local member, Councillor James.
Chairman, I'm really pleased with this scheme because I think all the key elements of protecting the residents and the interest of people who adjoin this site have been taken into account and dealt with very carefully. I think the applicants and the owners of the site have responded to the conditions imposed upon them properly, and I think the application before us, as Marcus rightly says, is reserve matters. So all the main issues have been dealt with without the matter for appearance, landscaping, layer and scale. So on that basis, Chairman, I move approval of this application.
Thank you, Councillor James. And seconded by Councillor Bird. Any other member? Councillor Mark Wilson.
Can I just, someone's got my, thank you, Jim. Can I just draw members' attention before we go and vote on that matter? On page 86, it's in relation to Network Well and the crossing. Now I know that it's been an issue in this area for a long time. And Network Well, I've noticed, not just in this, but in other applications we have seen today, are also objecting to the fact there is going to be no pedestrian crossing. And I just wondered, perhaps, when will that be resolved?
We've actually had very recent discussions with Network Rail, and they can't have this application approved quickly enough, is their view.
Okay.
Because obviously the path that runs along the bottom there will provide an alternative method for getting to the station, will also provide an alternative method of getting from north to south, because although it is a slight diversion, it means that rather than having to cross the railway line, you'll be able to go out to the road, down and into the site that way. So as far as they're concerned, the sooner there's an alternative to crossing the railway line, the better.
Okay.
Thank you on that.
Thank you. Well, it's been moved and seconded. Are members all in favour of the officer's recommendation? Please show. Well, that's clearly carried. Thank you very much for that. Moving swiftly on, I believe there's another application, a reserve matters application for land at the north of the railway line on page 102. Marcus, would you like to go through that?
Thank you, Chair. Yes, this is the other part of the outline site, which obviously members considered in early 2014. You will see that it's pretty much a continuation of the scheme that was just been approved. This one doesn't include very much open space, but obviously that is catered for in the block that is on the Persimmon part of the site. You will see affordable housing is shown on this site. It's still actually pretty well pepper potted. It's not perhaps in the central part, but it is obviously to the north and also to the south. They have complied with our policy in terms of trying to minimise big blocks of affordable housing in one place. This scheme is by and far a much smaller scheme. It is only 126 dwellings. But again, you'll notice the loop within the site that goes right round the houses. So again, they have tried to minimise cul-de-sacs. And in fact, the top part of the site, which is to all intents and purposes a cul-de-sac, actually has pedestrian linkages through to the main spine road through. So again, we recommend it. It is a good scheme. It has taken a long time to get here, but it is a good scheme. Deals with all the issues very well, and will hopefully go some way to resolving some of the issues residents have with drainage and other matters in due course.
Okay. Local member, Councillor Jeff James.
For the reasons I gave before, Chairman, I'm happy to move approval of this application as well.
And I noticed Councillor Bird was quickly up with his hand to second it. Thank you for that. Any other member? Okay, move swiftly to a vote. All those in favour, please show. Well, that is unanimous. So thank you for that. Moving swiftly on. I believe this one was a site visit today, which was asked for by Councillor Mark Wilson. I know he wasn't at the site visit, but I think he wanted people to get a flavour of the site itself. So I'll ask the officer to run us through the report, and no doubt he'll have a proposal. Thank you, Marcus.
Thank you, Chair. Yes, this is an application for an infill 3-bedroom detached dwelling in the garden of 1 Hastings Avenue in Penarth. It is a detached property in a pretty much uniformly semi-detached property close, although there is a detached property opposite this site as well in a similar sort of layout to this. The property is not particularly large. It is 7 or nearly 8 metres wide by approximately 6 metres deep. It has a maximum height of 8.2 metres, and I know Councillor Parker pointed out on site that I think the plans have become a little bit squashed in the report because it looks a little bit out of kilter there. But if you look at the actual plans, they are where are they? What's happened to it? It's now not moving. Ah, there we go. Sorry. It is mirroring the height of the 2 semis either side and the semi in which the garden is being built. And I have checked on plan, and actually the roofs are all the same height, just under 3 metres. But you wouldn't think it from that plan, would you? Because it does look quite high. But so it is, in general terms, trying to fit in with the street scene. I know there have been some concerns raised about on-street parking and the possibility that this will cause additional problems. You know, I have mentioned on site that if you wished, we could amend that parking arrangement, and that's something that if members wanted to do, that would not be a problem, because it would perhaps minimise the loss of on-street parking if that was to happen. But in general terms, your officers recommend it to you. It generally meets all our requirements. There is one deficiency in terms of open space provision, in as much as you can't quite get 70% of the space for 1 Hastings Avenue into what is considered a private area, i.e. the rear. However, if you look at the plan, if I go back, that does, if you look at the area to the rear of the parking for number 1, we, in terms of our supplementary planning and guidance, wouldn't necessarily call that a private area. However, if you were to put a fence up there, clearly it would be private and it would be rear. And if that was to happen, then it would give you your 70% of space. And I think I did mention on site, unfortunately, most inspectors don't accept that as a reason for refusing an application anyway.
Okay, we'll take Councillor Gwyn Roberts first.
Thank you, Chair.
And then I'll take Mark Wilson.
Okay. Thank you, Chair. This, as I said earlier, this actually was considered by the Dartmouth Council, and they commented on page 134. They have concerns about the overcrowding because it's quite a congested area, but the particular concerns were in respect of traffic, because particularly outside the working day, it's a very congested area, quite narrow roads. However, having been on the site visit today and had the expert advice of the planning officers, I realised in a way we don't have really sufficient grounds to simply refuse it. But if we can make amendments to the way the access to the off-road parking areas are, that would ease a number of dimensions, not the least of which is, although it's not a valid planning matter, there are 2 very attractive houses alongside which are quite well known in the area, and in fact it would better frame those houses. So if we can modify the access so there is one area, it would increase some, it would give a few parking spaces or effective parking spaces on the road, and would also improve the outlook on the other house. So I have asked Marcus if he was willing to sort of draw up a condition on that basis.
Marcus?
Yeah. Thank you, Chair. Yes, I have drawn a condition up just to sort of deal with that. I'll read it out quickly. It's a bit dry, but notwithstanding the submitted plans, details of the proposed parking for both the dwelling hereby approved and 1 Hastings Avenue shall first be submitted to and approved in writing by the local planning authority, and these details shall provide for parking for both properties to be centralised in a single block of 4 spaces, 2 for each property, with only 1 set of dropped curbs. No part of the development hereby approved shall be brought into beneficial use until such time as the parking areas, including all associated access areas, have been laid out in full in accordance with the details hereby approved, and shall thereafter be so retained at all times to serve the development.
Couldn't have put it better myself.
Perfecto. Councillor Wilson.
Yeah, can I apologise for not making the site visit and to work commitments. But nevertheless, you know, I do feel that I think the members who were there did benefit from seeing it, and I think this new additional condition, I think, will help the issue there on that particular site. But I am generally concerned, that we are getting quite a lot of these sort of houses in almost in backyard developments of estates. That's a general point, and I am got concerns about that. And I am aware that these particular estates are designed in a certain way, and in some ways, you know, by doing these small developments, you know, we are going against that. But I understand the planning policy, I understand where we are. I'm a pragmatist on this matter.
Thank you for that. Any other member? Okay. Moving on to the officer's recommendation to approve this house. All those members in... subject to an amended condition, which Marcus read out. Anybody want it read out again, or are you happy? Okay then. Officer's recommendation to approve. Those in favour? Those against? Councillor Kevin Marnie is against. But otherwise, that's fine. Okay then, right. And Chris Fanks, did you abstain? Or fell asleep? You'll vote against. 2 votes against then, if that can be recorded. Thank you very much. Moving swiftly on, I think this takes us to the 3rd application for Roos Point, if I remember, and it does. This is the land to the south of the railway line, Trem Etchney, Roos Point. This is on page 147, and I think Marcus ought to lead us through it first.
Thank you, Chair. Yes, this is a site which has previously been approved in full for 87 dwellings. I won't go through the long history of the site, but the site was originally allocated for retail and business uses in the land south of the railway proposals. During a long and protracted history, it was shown that they couldn't be used for those purposes, and ultimately we ended up approving 87 dwellings on the site. That approval was at the time subject to condition 11, which sought to prevent no dwellings being occupied until such time as an updated solution to the sewerage system had been provided via a hydraulic modelling assessment. That was required by Welsh Water, that condition, at the time members considered it, because of concerns about the downflow of sewage from the site and issues which were already occurring on the site. It is interesting to note that actually Welsh Water are not yet the sewage undertakers for this site. It is in fact the council, because, again, I won't bore you with the long history of this, but because of the way this site was developed and the original site developer going bust, the council ended up taking on the responsibility for sewerage facilities on the site, sewage pipes and runs on the site. The sewage system is about, or was about, to be adopted by Welsh Water on at the end of March. Due to a minor technicality, as I'm advised by our drainage engineers, to do with the type of software that Welsh Water run in respect of the telephone warning systems for their pumping stations, and the fact that the one the Vale of Glamorgan had installed, didn't match the Welsh Water one. They were unwilling to take it on until that was resolved, and it is now programmed to be taken on by Welsh Water in June. But in any event, it is worth noting that in 2016, however much time more Welsh Water may want to prevaricate, they can't, because under legislation they have to take on all private sewerage systems. So the time is fast approaching in any event that they have to take this on. What has happened is that since we approved this and the developer has progressed the scheme, Welsh Water have changed their mind in terms of what dwellings could be occupied with regard to this development and the capacity of the existing system. And they originally told the developer in, I think, mid-part of last year that they felt 20 dwellings could be occupied without having any impact on the existing sewage system. Of course, the developer came straight to us then and said, well, we need to vary this condition. they made a couple of aborted attempts to do it. One through a non-material amendment, which we told them, well, it's not a non-material amendment, it's a variation of a condition, so they withdrew that, and then they came in with this application. Welsh Water have reiterated their stance that they feel that 20 dwellings could be accommodated within the existing system without having to implement any of the requirements of the hydraulic modelling assessment, which has already been undertaken. Our own drainage engineers, who are technically actually the sewage undertaker for this site until Welsh Water take it on, have looked at it in some detail, and they're in the late representations, their comments there. They are adamant as well that the 20 dwellings will not lead to any problems with the system. I think it's worth noting actually that the pumping station that has caused many of the problems here is not affected by this development. It's downstream or upstream of it in any event. However, just to give you a bit of background, this pumping station back in 2013, and probably Councillor James and Councillor Clark can give you more accurate details than me, but in 2013 failed, and no one knew about the failure, and it led to an overflow of sewage out into the pond on the site and the water courses and all sorts of problems. Since that issue has arisen, a warning system has been built into, and large parts of the pumps have been changed, and a warning system was built into the pumps so that if they ever failed in the future, the monitoring organisation, which is currently the council, but obviously will be Welsh Water, is aware of it immediately, and it's a 24-hour monitoring system, and the pumps can, an engineer can get to the pumps within a very short space of time, and the issue should be able to be resolved without any backflow at all. That can be proven because last weekend, typically, just after Welsh Water said we're not taking it on until you change the telemetry, both drive shafts of both pumps failed and sheared, and they were the only parts that apparently hadn't been replaced on these pumps by the council. But although that issue arose, there were engineers on the site in a very short space of time, and those drive shafts were replaced, and there was no need to bring in pumps from anywhere else to deal with it. It was dealt with. The system is working again. So, to sort of come full circle again, both Welsh Water and our own drainage engineers are telling us that 20 houses can be built on this site and occupied on this site, in having regard to the existing sewage system, before any further upgrading work is done, and we are recommending the condition is amended accordingly.
Oh, thank you for that. Well, we've got another hydraulic modelling engineer here who'd like to speak to committee. Name of Councillor Clark. Thank you.
Thank you, Chair. Yeah, there have been multiple failures of this pumping station in the last 6 months. I've been telephoned by some residents who expressed their concern because, as Marcus quite rightly says, there's been a discharge of sewage into the lagoon on more than one occasion. I reason to believe the current pumps are on hire and new ones have been ordered, notwithstanding the breakdown of and repairs that have been committed. It concerns me on page 150, where it says highways and engineering drainage. It says, although we manage the pumping station, it's due to be transferred to Welsh Water on the 25th of March 2015. Well, it hasn't been transferred, and Welsh Water haven't adopted the pumping station as yet. And it's difficult to find out exactly why, even though they've raised no objection to the addition of these 20 houses. It gives the residents some concern in the track record of the failure of this pumping station.
The chairman should be told off, I think.
He should be fined a pint tonight.
I'll find out who that is. Daughter.
I thought that was a bell for me to stop talking.
Go on, carry on.
We'll add you another half-minute on.
Stop the clock.
There's been previous correspondence also that stating that residents could be liable for costs regarding the maintenance of repairs to the pumping station. So, mindful of the considerations I've outlined, I asked members to consider if you were living there and there was a calamitous issue that developed and the pumping station wasn't adopted, then life could be quite difficult. So that's how I see it, and I wish members to defer this until the pumping station is adopted.
Okay. Thank you for that, Councillor Clark. Now we again have a contribution from Councillor Jeff James.
Yep.
Thank you, Chairman. Can I reiterate to some extent what Mark has said and what Councillor Phil Clark says? That the residents and Councillor Clark and myself were delighted to learn that Welsh Water were going to adopt the pumping station in March, and we're devastated now to learn that they haven't done that, and they found a small telemetry issue. It seems minuscule when you consider the pumping station in the whole, but I think it's fair to say that the whole of Roos Point had the sewage, the foul drainage adopted, because there was new legislation which came in which forced utility companies to take on the foul drainage. So the Roos Point is adopted, the foul drainage is adopted, the surface water is not. That drains to the lagoons. But of course we have this anomaly whereby the foul drainage drains to a pumping station which Welsh Water refused to take ownership of, responsibility for. And we keep getting very close to them doing it, taking on that, but each time they come in to look at it, there seems to be another problem. So for the residents who are used to seeing breakdowns, are used to seeing sewage discharging into the lagoons, are used to, in some occasions, to see sewage shooting up into the air from the manholes for a fair old height. So imagine their disappointment to discover that the Welsh Water's adoption didn't happen again. To some extent, what the residents are really concerned about now is that, as bad as it's been with the existing site, we're now talking about adding a further 20 houses. In other words, exacerbating the problem. And whilst we say that the council has the responsibility for the pumping station, in reality, it's a shared responsibility with the residents because it's not adopted. And the residents are not only worried about the environmental health impact, they're not only worried about the inconvenience and the concern about what's likely to happen to the pumping station. Will it break down? Will there be environmental impacts? But they're also worried that until that pumping station is adopted by Welsh Water, that there could be a call on their resources to do something about that pumping station. Luckily, the council has taken the lead and taken on all costs to date in resolving that pumping station. So the fact that Welsh Water was going to take on this pumping station and adopt it in March and now haven't, I think has a real impact on this application before us, because Welsh Water is saying that they feel that there's 20 house capacity on a pumping station that they don't own. The council is saying that there's a 20 house capacity. Well, that's fair enough. They're actually responsible for it. But the residents are incredibly fearful that 20 more houses will just make the matter worse. And I would like to ask the members to consider whether we could defer this application to the next meeting, and in the meantime see if we can't get the council, the technical issues and Welsh Water around the table and adopt this pumping station PDQ, because that is the only way that the residents of Roos Point are going to sleep at night without worrying about what's going to happen with the pumping station and what the liabilities and impacts are on them. So it's no other reason that I'm moving this, Chairman, other than to protect the interests of the residents, because quite clearly Welsh Water's views on this are as an interested party but not a responsible party at this time. So I'd like to move that we defer for that to happen, Chairman.
Okay, I think there are a number of speakers. The only thing I would say to that, Jeff, is that I know Welsh Water are going to take it over in June. We're in the middle of April. I don't see how 20 houses are going to get built between now and April, so I can't logically see how that's going to happen. They're built, are they? Right. But they're not occupied. Right, okay. Proposal. Okay then. Well, I'll move round the... I know I've got Councillor Mark Wilson next. Yeah.
I've got a lot of sympathy what Councillor James has just said, because we've got a bit of whipmanship here, it seems to me. We've got one point Welsh Water stating on the actual application that they don't mind, they haven't got a problem with this happening, and at the same time they're not adopting the pumping station. Well, to be honest, we can also play poker as well. If anyone play poker, we play poker. Okay? And I'm quite agreed that I think we should defer the application. Because I simply think that sometimes, you know, we understand Welsh Water's got considerations, it's got limited budgets, it's got limited resources. We all have got limited resources and limited budgets. So let's defer it for a while and let's see what happens.
Okay, Councillor Marnie.
Yeah, just have to agree with everything that's been said. I mean, I'm just staggered that it's even been discussed, to be honest with you. I mean, I know, appreciate it's been brought before us, but what's the rush for 20 houses? They know what the deal is. None of us who ever buy in a house, we can ever consider we bought that house till the very instant of that contract signed. Seems to me Welsh Water. It's no good saying, oh, they are taking over in June, they are taking over then. We'll take it over. Let's discuss it then.
Okay, Councillor Hodges.
Thank you, Chairman. Councillor Mark Wilson beat me to the poker analogy. I was going to use that one, but I was also going to say that if we pass this tonight, we're already chucking our hand in. If they were going to do it in March, which they didn't, if they're then saying they're going to do it in June, well, let's wait till June. Let's make sure that they take on their responsibilities and we get rid of ours. Basically, I'm happy to defer this, Chairman.
Okay, Councillor Hartree. Right, okay then, thank you. Councillor Gwyn Roberts.
Thank you, Chair. I endorse the other speakers, what they're saying, but what I would like to add is perhaps we could ask Marcus is how we can move this on to resolve it. It's no point in just delaying it as a poker hand to keep that analogy going. What we actually need to do is find a way of resolving it, and I just wonder if Marcus can offer us any way forward to try and resolve the impasse.
Okay, Marcus.
I can't offer you a way forward to resolve the impasse. That's only Welsh Water can do that in terms of taking it on. And what I could offer you is an alternative, which is that you condition that, rather than removing the condition in its entirety, you condition that 20 houses be occupied once Welsh Water have adopted the system. Now that would be an alternative you might want to consider.
So better. Yeah, we'll take Councillor Ray Thomas, but I think he's stunned by that proposal.
The only comment I want to make is Welsh Water. We have the problem in Colwinston, the pumping station, which fails regular, and Welsh Water have got their system in to tell them in time, but usually it's the residents tell them, and it'll be another week, 10 days before they get out there. So I haven't got much faith in Welsh Water in their response to things. Perhaps our council equipment was a lot better than theirs.
Could well be. Well, we've got a late application here from Councillor Penrose. We must have him speak.
Yes, thanks, Chair.
Thank you.
I'd endorse what was said by Councillor James and the residents of Roose Point, but also referred to by Councillor Clark, and that is that by granting this, if we were to, the 20 people that would purchase these properties could inherit a problem if the calculations are wrong, and I think that's just adding 20 more residences to the people in Roose Point are already very suspicious of it. So again,
I would thank you
go
for
along
that,
with
Councillor
sentiment.
Penrose. Are you going to add something different to the
No,
proceedings?
just to say, Chairman, that obviously if we put this condition on now, it will appear on any searches and that will alert 20 people to the fact that they need to make sure that Welsh Water have adopted the system.
Very good. Good point. Council. Suggestion that we add an additional condition, and Marcus is just going to read it out, and subject to that I'm going to move to a vote.
That's all right. No, it's there.
No.
So we basically will be just reading what we've had previously. We don't need the hydraulic modelling assessment because that's already been done. No dwelling. No, sorry. 20. A maximum of 20 dwellings shall be occupied. So a maximum of 20 dwellings shall not be occupied until such time as the sewage system or the sewage pumping system, identifying the sewage pump by number, has been adopted by Welsh Water in full, and that's all we need to say.
Yeah.
And the reason would be to protect the integrity of the existing sewage pumping system.
Gwen,
so that's it.
You want to come in before I take a vote?
Yeah, I don't know whether I just misheard Marcus, but I thought there'd be no dwellings occupied until it's been adopted.
That's
not
what he
maximum
said.
20. Oh, sorry.
No,
Well, none should be occupied. Yeah. Okay.
Not to be occupied, he said. I think, first of all, I think Councillor James is going to have to remove his first application, and it was seconded as well. Provided that you can take that away from the table, we can go straight for a vote.
Suggestion made by Marcus that no dwelling be occupied until such time as the pumping station at Roos Point is adopted by Welsh Water.
And your seconder?
Maximum of 20.
Happy?
No, it's all of them.
Okay then.
Oh, even better.
Just very quickly. It is no dwelling, but after that it'll still have to be a maximum of 20 because there are other works identified by the height which don't affect this pumping station, which are identified which need to be done. Yeah.
Okay, members happy with that? All in favour? Well, that's unanimous, so that's clearly carried. Thank you for that. Yeah, it's well worth the debate. Okay, subject to a site visit this afternoon. It was the Chenewid Inn down at Chenewid Road in Barry. Marcus, if you could lead us through this.
Thank you, Chair. Yes, Chair. This is an application. This is quite an interesting application in one respect. It is an application to site 7 hard standings, very small hard standings, to site 7 tables and chairs on for use in a beer garden. The beer garden use itself is not a change of use and doesn't require planning permission. The 7 tables and chairs could be sited on the area without planning permission whatsoever and operated as a beer garden, and there's nothing the council could do to stop that under the planning regulations. So we are only considering the 7 small hard standing areas that have already been put on site. It's difficult to actually, I know a lot of the concerns that have been raised relate to the noise that the beer garden could generate and the possibility of late operation in the summer nights, leading to noise and disturbance to the nearby residents. And one issue I think members have to consider is that there is a licence, this is a licensed premises, and if that were to occur, I've spoken to obviously the council's legal officer, Richard Price, and he has pointed out that were there concerns raised and complaints made about the noise which emanated from the beer garden, the licence could actually be subject to review, and the licence could include hours of operation of the beer garden if that were to happen. So that is probably the place, if you wanted to control the operation of the beer garden, where that should be done, because as the use itself doesn't require planning permission, we could not impose conditions on which sought to limit the hours of operation.
Thank you for that, Marcus. I suppose if the neighbours were all upset, they could always go to the chair of licensing, couldn't they, if I gave them their number? Oh,
And the
sorry.
chair of licensing called it in.
Oh, right. Any member?
I think.
That's okay.
Yeah.
First of all, I'd like to thank Marcus. When I raised concerns, having been approached by local residents, Marcus acted swiftly and immediately arranged for an enforcement officer to go out, because it's not just about what development is going on, it's also about the way you go about it, and the way that this development has progressed has shown no respect whatsoever to local residents. To come home and find that your boundary fence has been removed and there are strangers working in your garden on your property, and now there is no boundary between the local pub's car park and your garden, I think is quite unacceptable. But again, it's not a planning issue. But I wrote also, because as a result of the enforcement officer visiting the site and making representations to SA Brains, that resulted in SA Brains withdrawing their original planning application and putting in the application that we see before us this evening. And I suppose, having raised concerns, I'm disappointed that it's here in this form. And having written to Brains, you know, perhaps a dialogue could have taken place and some common sense could have ensued, because you know, I believe that this beer garden could have been better sited. I think that it could have been better sited, even perhaps as a continuation of the existing beer garden type facilities which are already at the front and to the one side. It could have just wrapped around and been nowhere near the boundary fence of local residents. Unfortunately, that didn't happen. But I will accept, of course, and I understand that there are no planning reasons to vote against this application. And if we were to refuse this application, it will go to appeal, and we will lose at a cost to the ratepayers. There have been no contravention of planning laws, but this is a classic example, in my opinion, of inconsiderate landlords, where SA Brain has showed no consideration for the local residents. So I will vote against this application on those precise grounds, that I believe that it is inconsiderate, it is insensitive, and it is unsympathetic to local residents. And really, that's all I've got to say.
Thank you for that, Anthony. I know Nick was eager to get in as well, so over to you, Nick.
Thank you, Chairman. I'd add another adjective to that, and that's outrageous. Firstly, we heard that this could be controlled under licence, and if there have been complaints, they could be taken up. Well, there's complaints within the late reps from the residents themselves already mentioned. Also, I have to remind Council as well that under consultations it said Barry Town Council raised no objections, and of course that's in the late reps, and they certainly have raised an objection saying it caused unacceptable harm and serious disturbance to the amenities of the occupiers due to unacceptable late night lighting, noise and disturbance, and I fully concur with that. Now, my confusion here is that this is called in the application a landscaped trading area. Well, it's a beer garden. You can see that with the tables, you can see that with the ashtrays there, the upturned new modern trendy way of doing ashtrays, which are plant pots. We also have down in here in the application no conditions. So it's to accept, approve with no conditions. Yet on the back papers of the late reps, we have 4 suggested conditions there. They don't fully, I suspect, if we accept those, please the residents, but it's a start. But my concern is that it's an unneighbourly way to trade and run a business. I suspect that we're on a no-hoper here because it's a piece of land that they can use. But the very fact, what Tony there said about them going on to residents' land, uprooting fences and rearranging in that way, I think is utterly outrageous. And I would go absolutely Billy bonkers if anyone tried to do that with my property. I have I have to turn this down, Chairman. And I think this is something that needs to be tested if necessary, if there is an appeal. So I will refuse it. And I will, in fact, if you haven't done it already, Tony, did you move it? Go on, you can move it. You're the local boy.
Yeah, Marcus.
He's moving it. I'm seconding it, Chairman.
Okay, we've had a mover and a seconder. Marcus wants to come back on some of the things you've said.
Not really on any of the things you said, but just to point out that you couldn't take enforcement action against this because we're not talking about the use. If they took the slabs up tomorrow and left the tables there, we could not do anything about it. They could carry on trading to their heart's content. If we imposed conditions on hours of operation, again, they take the slabs up, move them out. We can't do anything about it under planning legislation because the only thing that needs planning permission is the putting of the slabs there. And I really am cautioning you against refusing this because this could well be an application for nothing, which leads to costs against the council, because we have to recognise the fact that the use can happen with no planning control over it at all.
Yes, come back.
Well, the application, as you said, is for 7 square concrete paved areas. I'd like to refuse that. If, as you're quite right, they wished it to be used as a grassed area, use it as a grassed area. And if it rains and gets muddy, I suspect the punters won't like it very much. Well, if that actually helps them not to use that site, I'll be more than gratified with that. Let's not make it easy for them, Chairman. I think this is an outrageous application.
Councillor Gwyn Roberts.
Thank you, Chair. I lived next door to a pub for many years, and certainly some of the antisocial behaviour that's quoted here does go on because you simply don't have control of your customers. However, there's a bigger issue here. We have to retain credibility as a planning committee, and Marcus has made it absolutely clear these are for the concrete slabs, not for the people standing on them or sitting next to them or drinking the beer. This council has other ways in which it may help these residents, both through licensing and through environmental health and public nuisance. And I think, frankly, to try and refuse it on the slabs, where we would lose, would simply damage our credibility and achieve nothing else. What I would suggest we should be doing is tightly using the licensing and environmental health laws to help these people, and that way we retain our credibility. And I really think that's the way we should take forward. We should take a cool head and try and get success, not just make futile gestures.
Thank you very much. Any other member? Councillor Audrey Preston.
Yes, I am here, Chairman. I'd like to support this because it's a very small planning application and there's a lot of outdoor things in the summer, and this sort of weather I think it goes very well. I don't see how we can. I think we're very silly to try and not support something as small as this.
Yeah. Thank you for that. Councillor Kevin Marnie.
Officer, I do support what these guys have said. I'd ask Audrey, do you live next to a pub? You do you? Yeah. Oh, well. No? Yeah. Okay, I'll leave it at that, frankly. Yeah. Well, if you'd have come to the site visit today, you'd see the 1 yard between that beer garden and the old couple's house next door. Perhaps you should have come along and had a look at that.
Okay, then.
New fence in there. It's all new fence.
I was going to move to the vote. If you want to come in again, I'll allow it. But
We have to move to procedural.
yeah, you've got to give reasons for refusal, otherwise we'll be getting ourselves dog-knotted.
Would the
the reasons for refusal is that it is totally unneighbourly. You know, I mean, I just wanted common sense to prevail here, and there are better positions within that car park, within the you know, the curtilage of the Tynwyd Inn, that, you know, would probably have appeased the local residents. It would have still given Brains the outdoor drinking area that they they would like.
Yeah.
Just a little bit of thought and common sense. It might be a futile gesture, and yes, you know, having obviously a little knowledge on licensing law, there is probably a way that we can deal and help the residents, you know, at licensing. I also accept that the fact that, you know, I've spoken strongly here this evening, I would not be able to take any part now in the future deliberation by licensing, and I'll accept that as well. But I feel for the local residents. And I would, if any one of us were living as close to this beer garden as the local residents find themselves living in, I think that you may have a different attitude. And, you know, morally, we should be voting against it. As far as planning law is concerned, we should be voting for it. That's a dilemma for the individuals of the planning committee to make this evening.
We haven't got a reason still, but I'll let Marcus.
Can I just point out that any reason has to deal specifically with what's applied for. So it would have to deal with the concrete slabs, not with the use of the land. You can't refer to that. You have to refer to why the concrete slabs are unacceptable.
Okay, so we've heard that. Councillor Jeff James wanted to come in.
Chairman, I had the benefit of attending the site visit. I could sympathise with the members who have spoken against the application. That obviously that some of the neighbours are not happy with the use of the area that we saw, and whilst I sympathise, I think I've also got to bring people back to reality and say it was made clear to us on the site visit that the application relates solely to the slabs that have been placed underneath the bench seating, and that we don't have before us an application for a beer garden, and we're certainly not the licensing authority. So I think that it would be using the planning process to gain a refusal for no other reason than members take the opportunity to do so. And I think in reality, members of the committee know that all we have before us are the slabs. And I know it's been moved and seconded refusal, but I would certainly be voting against that.
Councillor Penrose.
Thanks, Chair. There are several points. I mean, I agree with what has been said by Councillor Powell. I think it's a total disregard. I also, and you know, I have a personal hobby horse about retrospective planning applications. It shows arrogance on part of the developer, whether it be 7 paving slabs or a block of flats. The correct procedure would be the application to be heard before anything started. But the one thing that concerns me, remember, this committee, is our own public protection officer who has written against the scheme because of the annoyance to neighbours. Could we not look at a deferment of this application until such times as it's been put to the licensing committee, because it does make or have effect on our judgment on this matter?
Right.
They're two completely separate pieces of legislation, and they can't cross. No. In the same way as we can't control when the council imposes conditions on takeaways, for example, in terms of hours of operation through the planning system. If the licensing system changes those, duty bound to listen to the licensing because situation, because it takes primacy over planning in matters relating to issues such as that. So for it to do what you've just described, and I think we need to consider the comments of the Environmental Health Officer. They are making cautionary statements which would be very relevant to the licensing committee. They're not relevant to the planning committee because we do not have a beer garden use being considered, and that is, unfortunately, we did make this point to the officer who made the comments, but they are making cautionary comments as they rightly do when they have concerns about what is going to happen when that beer garden is used. But I come straight back to the point that Brains need only take the slabs up, and they don't need planning permission. And indeed, do you really think we're going to serve an enforcement notice on them to take the slabs away from there? Because that would achieve absolutely nothing. And otherwise, you are really not achieving anything with what you're doing, other than really, as Councillor Roberts quite rightly said, bringing the council's planning system into disrepute, because it will achieve nothing.
Councillor Parker first.
Yes, thank you, Chair. Actually, Marcus has anticipated the point. If we refuse this, we'd have to ask him to instruct the enforcement department to have put an enforcement notice on 7 slabs. Well, we would be laughed out of court in every direction on that thing, and you could not actually achieve that. So, regretfully but correctly, we need to approve this decision.
Councillor John Drysdale.
Thank you. I understand the distress of residents in this, but I think we've got to look at what is the outcome, which is essentially what Marcus was talking about. If we refuse this, what will the outcome be for residents? Will it improve their situation or will it not? And the outcome will be that the slabs will stay post-appeal and nothing will change except that council taxpayers of the council will have a small additional burden, or modest even additional burden. This is trying to use the wrong tool to fix the problem, and we shouldn't do it. It is irresponsible. The fact that we haven't heard a reason which stands in planning terms as being valid indicates that we would be irresponsible to take the decision to turn this down. I'm sorry, but we've got to find a different way of getting a better outcome for the residents, not this way.
Councillor Hodges.
Thank you, Chairman. We've been told a couple of times that we're not talking about a beer garden. That's not the application. But the actual description of the application is a landscaped trading area. If you look at the pictures, it's a beer garden, and that's what it is. Now, I understand the difference between having a beer garden with concrete slabs, which is the application, and they're already there, and an application for not having concrete slabs. Well, this is an application for the concrete slabs, and I object to them. If they want to set up a beer garden without concrete slabs, let them do so. It'll be a far worse application for them, and it's something they should have come to us before with. They withdrew an application a few months ago for another similar type of application. I just wish they'd actually come to us and discussed a way to actually not only improve their premises, but actually keep the residents happy. I'm still going to object to it, Chairman.
Thank you. Audrey Preston.
Thank you, Chairman. Don't you think the bottom line is, if you buy a property next to a public house, you've got to expect noise?
No, that's done.
Okay.
50 years ago it was
You didn't want to say anything then, Gwyn, did you? No. Okay then. Well, Councillor Bob Penrose, the second time.
Just a brief point, Chair, to Councillor Drysdale's statement. I refer him to Welsh Government recommendation in their planning bill, and that is that reference to whether it costs money to go to appeal should not be a relevant issue, and we on this panel are really looking at the better interests of the residents of the Vale of Glamorgan as well. And I think a sword of Damocles being held above us on cost is not a relevant issue. We should do what we think is right in this matter.
Yeah, Councillor Drysdale.
The cost was a secondary consideration. To do what's right on this matter in planning terms is to let it go through, because there is no sound ground in terms of planning policy to turn it down.
Okay. We've had a mover and seconder to refuse this. I don't know whether the council lawyer wants to say anything about it, because we haven't really had any proposal have we? No, we've got no reason before us at the moment. Turn your microphone on and give us the reason.
I'll reiterate what Barry Town Council said. Unacceptable harm and serious disturbance to the amenities of the occupiers due to unacceptable late night lighting, noise and disturbance.
That's nothing to do with the slabs, is it?
That's not. But the use is not. It's not. There is no application for the use as a trading area. The application is for the installation of 7 square concrete paved areas in a landscaped trading area, not for a landscape trading area. It's in a landscape trading. And the fact is that that does not require planning permission. So any reason of refusal you come forward with, which says the effect on the neighbours through noise and disturbance, is not relevant. It has to be in terms of the appearance of these concrete slabs, which are physical development.
To stop them, Chairman, turning the whole of the car park into a trading area then, is there? Or a beer garden?
Only licensing.
Would it be helpful, as there's no valid reason being given to justify
defer it,
a decision to either to defer or refuse this, I'd like to move that we actually officer's recommendation on this application.
Have you got a seconder? Okay. Yeah, we've had a mover and a seconder for the officer's recommendation. It does say in here that I can move to that now. Yes. So yeah.
Sorry.
Yeah. Can I say no, because we're going to go. In what way?
The application seeks consent for the installation. The application is to retain, because we've seen them today. So I think it should be that if we approve it, that means they're going to put them there. But they're already there. So we need to be very careful, particularly bearing in mind the climate, to take my...
I understand what Councillor Parker is saying, but actually they got a plan which shows them in the locations they are. I think, to be fair to them, when this application came in, they either hadn't been installed or they were about to be installed. So,
okay, right. So we move to the officer's recommendation, which is to approve these first of all.
You should take it the other way.
No, we shouldn't take it the other way. No, that's you. Were you in the training? Yeah, no. So the council officers are moving for approval. Those in favour of approval, please show. Ten. And those against? 6. Okay. So it's clearly carried. Any abstentions? No. Okay, it's clearly carried. Officers' approval. Thank you for that. I think that tidies everything up now.
can I just come very quickly back in?
Yeah.
Because, although we had the late representations for all the other applications, I am aware that one condition going back actually to application 639 Res was requested to be added, which is the land Pentradeer Roos, and I just wanted to make sure that it is added onto the agenda, and it is a condition for highway street lighting details to be submitted and are carried out in accordance with the details submitted, and that document is PYDRCC. It's a technical condition which wasn't included, so just to make sure it's minuted that condition number 4 is included.
Happy with that, Councillor James? Yes, that condition. All members happy then? Yeah, okay. We approve that. Thank you. Thank you for your forbearance, and good night.